unit we will be covering is the HIPAA privacy rule. And the objectives of this particular unit is to understand what the core requirements are for the privacy rule, what the key terms are and the concepts are as it relates to the HIPAA privacy rule. Next slide. The topic that we will be discussing next is privacy rule introduction. Next slide. Now, the HIPAA privacy rule was considered one of the most sweeping healthcare privacy laws ever enacted. Up to this point, there really were no nationwide privacy laws on the books. A number of states had their own privacy laws that related primarily to specially protected health information. In other words, special categories of information such as mental health, genetic information, HIV/AIDS, and so forth, which were considered especially sensitive. There were stigmas associated with them and so forth. But up until the point that the HIPAA laws were passed, there was no national foundational healthcare privacy and security regulations or requirements. So this amounted to a very significant move in the direction of mandating further protections of privacy and security. And one of the reasons that this mandate occurred was that the healthcare industry was interested in assistance from Congress to adopt that national standards for administrative transactions for health information. And Congress made the decision that if they were going to assist the healthcare industry in simplifying the administration, in other words, lowering the costs of exchanging data for healthcare administrative purposes, there would be a requirement that, given this was electronic data, that there would be a mandate related to privacy and security. And that is one of the key reasons why the privacy and security language was added to the administrative simplification provisions of HIPAA, and then that, in essence, became the privacy and security rules. Now, the objective of the rule is to provide privacy protection without hindering the quality of patient care, and also to increase efficiencies. In other words, there were privacy protections included, patient rights included, and so forth. But as an example, one of the primary examples that can be looked at is minimum necessary. Now, minimum necessary requires that only the minimum amount of information necessary for that particular activity, whether it's internal to the organization or sharing information with somebody else, is exchanged. Now, treatment was an exception to that, and the primary reason it's an exception is that there was a concern on the part of providers that appropriate or quality healthcare would not occur if they had to second guess what kind of information they could send back and forth between each other to assist in providing that quality of care. And it also did not limit the amount of information that could be exchanged that were part of what was covered as a HIPAA covered transaction. So in other words, a minimum data set is the transaction itself. So it said that if it is required for a claim, these are the fields, this is the type of information that's required. The minimum necessary is what is defined in the implementation guides for those particular transactions. So that, in essence, helped with the efficiency side while not compromising the privacy of the individual. Now, all HIPAA-covered entities are required to perform a thorough review of their privacy practices, clearly analyze the gaps, and take steps to bring the entity into compliance. That's an ongoing process, and this was effective April of 2003. So all covered entities should have gone through this particular activity and are on an ongoing basis maintaining their programs. And soon this will, actually now as a contract issue, it is required of business associates, and soon certain parts of the privacy rules, such as use and disclosure requirements, will be mandated by statute for business associates also. Next slide. Now, business associates are those entities that have a contract with a covered entity and they use and disclose on behalf of the covered entity protected health information. And use, again, is what happens inside the organization. Disclosure happens to be when it's extended or exchanged outside of the organization. So in essence, the exchange of data back and forth between the covered entity and the business associate, and business associates primarily fall into that category of organizations that have access to that covered entity's protected health information to assist them with a given task, such as billing, claims management, and so forth. Now, effective February 18th, unlike it is today where business associates must comply with the privacy rule by contract, but as of February 18th of 2010, business associates must comply with the use and disclosure provisions of the privacy rule by statute, which means that not only do they have to reasonably ensure